Hello, Mebane. I'm Ashley Oinby, Development Director for the city.
And I am Lawson Brown, City Attorney.
In this video, we are going to be reviewing the process for special use permits. Special use permits are also referred to as S.U.Ps or S.U.Ps, and they are for land uses that may be considered a maybe in zoning districts. The land use is generally consistent with what would be allowed in that zoning district, but should be designed appropriately and carefully reviewed. The first step in a special use permit process is for a site plan to be submitted to city staff and be reviewed through our technical review process. This allows for staff to confirm that all the standards of our ordinance are met and also review for land use harmony and consistency with our long-range planning documents. After staff's review, the special use permit moves to the planning board for a recommendation and then to either the city council or the board of adjustment for a public hearing. This public hearing is what makes special use permits so unique. It resembles more of a court setting than the typical hearing a city council would consider. Because of that, we have Lawson Brown, our city attorney, here today to help us through this process.
Generally, the special use permit is determined by a quasi-judicial hearing, and the North Carolina General Assembly has laid out the rules that counties and municipalities must follow by the enactment of North Carolina General Statutes, Chapter 160D, which was a land regulation statute. The special use permit, whether being heard by the City Council or the Board of Adjustment in a quasi-judicial setting, means that there are several technical requirements. First and foremost, all the witnesses who testify must be sworn in and testify under oath. Second, the council or Board of Adjustment, and in Mebane, the Board of Adjustment is in fact the City Council, which is different from some other municipalities. The hearing is the determining factor. The evidence presented in the hearing is the critical factor. The council cannot consider evidence outside of what is presented under oath in front of them that evening. The other important item for the council or decision makers is that they must reveal any conversations that they've had outside of the quasi-judicial hearing, and they must confirm that they will make their decision based on the evidence that is presented in the quasi-judicial proceeding. The legislature has also given guidance, and municipalities in North Carolina, as a Dillon Law state, can only take action that the General Assembly allows. And the General Assembly in Chapter 160D, Section 1402, has set the standard for the consideration of evidence. And the statute distinguishes between lay opinions and qualified expert opinions, and that is a critical factor when the council considers these. Typically, the applicant will have a traffic engineer who is qualified as an expert, and perhaps a site engineer that's qualified as an expert, and most likely a real estate appraiser who can testify. The testimony of experts is considered dispositive on the issue. Lay opinions are not considered by the courts to be persuasive and should not be considered by the council in making its decision. When I say lay opinions, I mean a person that is not qualified as an expert in one of the specific fields that we've talked about. A person can testify that the number of children that may be on bicycles in a particular area on sidewalks or streets, but they cannot opine that the traffic is too severe for the projected use. As Ashley has said, the special use permit is generally required when there is a more intensive use in a particular zoning jurisdiction than is typical, and there are very few uses that require special use permit in most jurisdictions, including Mebane. Ashley?
So in addition to our typical requirements that are defined in the Mebane Unified Development Ordinance that staff reviews, there are also 4 findings that the applicant is required to present on during a special use hearing. And that brings up some of the evidence that Lawson just mentioned. So those 4 findings are that the use will not materially endanger the public health or safety, will not substantially injure the value of adjoining property, will be in harmony with the area in which it is located, and will be consistent with the land use plan and other plans and policies officially adopted by the City Council. I think it would be helpful, Lawson, if we just go through those 4 points a little bit more and what they mean. So for will not materially endanger the public health or safety, you mentioned traffic studies. I know those usually are what are presented, but there may be other items that can come up to address safety concerns.
Traffic engineers are generally qualified as experts in the hearing, and typically traffic information analysis is done on these particular projects. And in that regard, the scope of the TIA is determined by the North Carolina Department of Transportation that participates in the Technical Review Committee, as well as by the standards that are set by the city in its Unified Development Ordinance. In addition to having the North Carolina Department of Transportation review a traffic engineer analysis submitted by an applicant, the city, at the applicant's expense, will also, the city will have that reviewed by our own expert, but again, it's at the expense of the applicant to ensure that there is complete transparency on the scope and on the conclusions that the traffic engineer makes.
So the second finding, that a use will not substantially injure the value of adjoining property, you mentioned real estate appraiser. Have you ever seen a case where you have 2 appraisers come and say different things? Or
I've had cases not in the setting of a special use permit, but clearly in courts, particularly in condemnation actions when the state of North Carolina may be condemning land for a highway or other project. I've certainly seen competing experts testify, and that's very typical. I have seen it rarely in the context of a special use permit hearing before a council or commissioners.
the last 2 points about the use being in harmony with the area and also consistent with our land use plans is something planning staff look at regularly with any type of rezoning request or special use request that come through. I think most of the time that it's relying on documents that the council has adopted and staff's interpretation. Do you have anything else to add for those 2 points?
Well, in harmony with the area it is generally determined by what is actually in the particular area. If the land is zoned light industrial or heavy industrial or any other business use that may and that the particular use may require special use permit, the zoning is not determinative of in harmony, but typically it is a big factor in whether a particular project is in harmony in the area with which it is located. It's very much related to the fourth point that we're getting ready to discuss.
So the fourth point, consistency with our adopted plans. We have the Comprehensive Land Development Plan in Mebane. We also have Comprehensive Transportation Plan, a bicycle and pedestrian transportation plan, a few others. Staff is looking at these in terms of the future of Mebane. They've been adopted with the future in mind. So if a area is identified for industrial and we have an industrial use proposed there that requires a special use permit, I would think that that would often be found as consistent. Lawson, this was a good conversation today, and we hope you all have learned more about the special use process. It can be difficult to navigate, and if you have any more questions, you're welcome to reach out to the planning department.
Thank you, Ashley. I think that the citizens understand that this process and procedure is to maintain Mebane as positively charming. Thank you.